This time we have a video panel discussion from Finland. This video recording has been put into action in collaboration with the Finnish Insolvency Law Association. I have the pleasure of chairing a very distinguished panel. My name is Lilius. I am the head of insolvency practice at Hannes Snellman. I'm also a council member and country coordinator for Finland at INSOL Europe. I am a board member of the Finnish Insolvency Law Association, and in practice I work as an advisor and IP in insolvency related matters. We also have in the panel Mr. Tuomas Hupli. He is an associate professor of procedural law at the University of Turku. He is chairing the Finnish Insolvency Law Association. He is an academic conferee of CERIL, the Conference on European Restructuring and Insolvency Law. Tuomas is a very known and distinguished expert on and specialized in insolvency law matters. We have in the panel also Ms. Helena Kontkanen, who is the bankruptcy ombudsman in Finland since August 2013. Insolvency Ombudsman's office is an independent authority supervising bankruptcy estates and undergoing restructuring proceedings. Helena is also a chair of International Association of Insolvency Regulators, IAIR. And lastly, we have Mr. Pekka Jaatinen in the panel. Pekka is a senior advisor at the law firm Kontkanen and Snellman. He's also a board member of the III, i.e. the International Insolvency Institute, and a member of the III Executive Committee, and also, like myself, a board member of the Finnish Insolvency Law Association. Pekka has been working very much with the largest and most complex cross-border insolvencies and transactions in Finland taking place during the last 30 years. The first topic for the panel today would be the expected rise of insolvency cases in Finland. Firstly, of course, I would address the first question to Helena, actually, and my first question is, do you see that there will be a rise of cases, of insolvency cases in Finland? And then again, does the profession of insolvency, is it ready to face the expected rise of insolvency cases, or is there any kind of a need for a restructuring of the profession? Helena.
Okay, thank you. Last year, year 2020, we had almost 20% less bankruptcy applications than earlier, and this was mainly because of these temporary limitations we had in creditors' right to file for bankruptcy. So this was because of COVID. And these limitations ended 1 week ago. And last week we had an increase of almost 60% on the bankruptcy filings. So we can see, and we know that some kind of flood is coming. Still we have in Finland a very strong group of IPs, so I'm sure they, and I believe this as a supervisor. Thank you.
So you don't see any problem in that regard. How about Tuomas? How do you think about this?
Well, yeah, thank you. Mainly, I agree with Helena. There's no reason to expect any problems regarding the readiness of the profession. The amount of cases is going to, rise. It has already started. But in Finland, like in other, if we talk about the Western countries, we have had many crises. We had the Euro crisis, we had we had the collapse of the Eastern Bloc, insolvency crisis. We're going to handle this. And the amount of cases is going to rise, but there will be diverse cases, basic and large cases. And we have IPs and diverse law firms who are going to handle this crisis as well as the previous ones.
How about Pekka? You have a lot of experience, of course, in connection with different kind of insolvency proceedings for the last decades. What do you think about this?
Thank you, Jan. I fully agree what both Helena and Tuomas already said, and I do believe we have enough IPs to deal and work with smaller and larger cases. Mainly the Finnish insolvency cases are small compared to some international cases, of course. However, restructuring work, especially large, complex, maybe cross-border cases, they do require various skills from IP professionals that we need to look into. Especially in cross-border cases, we need to understand the different insolvency regimes and culture. But I do believe we have enough people to handle with this.
So I think there is an agreement among the panelists that Finland has a strong group of professionals dealing with these cases, and there should not be a problem with regard to that. Maybe we move forward to the next topic regarding the preventive restructuring directive and the implementation of that in Finland. Firstly, I would like to just to know what is actually the timetable regarding the implementation in Finland. Do you have knowledge on that issue, Helena?
Yeah, we have a working group drafting a proposal implementing it, this directive, and it will end. The proposal should be ready in the end of April this year. But Finland has taken an opportunity for an extra year on the implementing. So this should be implemented latest in July 2022. So an extra year, as some other member states have already also taken.
Okay, so there's 1.5 years of time to implementing it. In other words, Tuomas, regarding the preventive restructuring directive, do you think that will there, from a Finnish perspective, will there be a whole new profession dealing with these cases, or do the same professionals deal with them as today?
Yeah, it's a good question. My initial answer that no new profession is expected. This is a new instrument of the union level, yes. And the Commission had the, how should I say this, fantasy that more companies would file for this new procedure earlier, that this should be a preventive measure. It's going to take years, perhaps decades, that this goal, this aim, the original aim of the Commission will be realized. And we are not expecting any new profession. Pekka, you, your colleagues, Helena is supervising us. I'm yelling from the university, do that, don't do that. We're going to handle this, but simultaneously we have young lawyers, and it is our responsibility to guide them, and we are happy to see their development. But regarding the preventive measure, it's going to take time. I hope someday it will be here.
Right. Pekka, do you think that the same professionals can address the matters as today?
Well, thank you, and I do believe that the same professionals really they do be involved and will be involved in these cases. However, I would say that some new skills we need to sharpen our skills in especially in communication and negotiation. Let's say I've said many times restructuring, for instance, it is communication, and cooperation with various stakeholders is of vital importance. So this is something, especially on the preventive measures before any formal procedures, we do need these skills, but still the same profession, I do believe, will handle the cases.
Right. Do you think that usually or generally companies file for restructuring proceedings too late in Finland?
Well, I think it's a common knowledge, not only in Finland, all over, especially in the continent, on the continent and in the Nordics, that we do find companies to file far too late.
Yeah, so it's kind of a last resort option, so to say.
Yes, which it should not be, and we should be able to use it like they do in US. They use the Chapter 11 as really a restructuring procedure.
Sure. Helena, do you have any thoughts about this particular issue? Is there a need for new professionals?
Well, same professionals, but as the others have stated, I think also these new skills are needed. We have or will have this early warning tools, and we should act in earlier stages. So there's a need for recognizing what can be done with businesses in early stages of insolvency, or even before that, these negotiations and all that. So I think in that way that will be a kind of new things coming along.
Yeah. So I think that it's a consensus among the panelists that companies seem to file for restructuring too late, and it would be, of course, more preferable that it would be done a little bit earlier than it is done nowadays. Regarding the as a next topic regarding the preventive restructuring directive, there is in Article 77 certain stipulation regarding the remuneration of the insolvency practitioners. Do you think that the Article 27 of the directive really changes the situation, the current situation in Finland regarding the remuneration of administrators? Or are well, let's say, I could say that the well-established practices in Finland such that can be followed also in the future? Pekka, you, of course, you have experience on these questions. How do you see this?
Yeah, thank you. And this is naturally always a question that creditors would like to discuss and are willing to discuss and are eligible to discuss, of course. But based on what I've seen in the Article 27, I don't think it will have much effect on the Finnish practices. As you said, we have a fairly stabilized coutume concerning their fees and costs of insolvency and restructuring proceedings, and then certainly we can and we will implement those practices in things and in the behavings concerning the directive. I think we need to realize that, of course, if we think about let's say large cases or cross-border cases, reasonable costs are always included, and to some extent maybe even to increase. But well, we need to be able to explain to our creditors and various stakeholders why and what the costs are and how they are borne. So the results, of course, will count.
Right. And Tuomas, any thoughts about the remuneration question?
Yeah, it's a question about money, which the whole insolvency law is dealing with. Yeah.
The lack of it.
The lack of it, yeah. But the aim is to create new money. Yeah, the same as Pekka. I don't see that this Article 27 would change the landscape of the Finnish remuneration levels. And every time we are talking about the fees of lawyers, it is useful to keep in mind that insolvency practitioners, attorneys, judges, we are a part of the administration of justice, and we have a common goal to deal with these cases in a proper way. It's not cheap, but I'm not worried about it. Agree with Pekka.
How about Helena? You are a supervising authority. What is your standpoint on this particular question?
I think there is no need for law changes in Finland because of the directive. We have general rules in the law and a demand on reasonable and fair fees for insolvency practitioners. So we need to have good people, good professionals, so they should be paid in a reasonable way. And then we have this lack of money in the bankruptcy estate, so we need to balance between these things. And in Finland we have this advisory board for bankruptcy affairs, and the board has given recommendations on the fees of IPs in bankruptcy, and these recommendations they are widely followed and also recognized in the court practice, and I think it is quite stable, and the level of the fees there's a common understanding of the level, so I think that won't be changing. Also in Finland we have this minimum of also in assetless cases the state pays 1,000 euros to IPs to take care of the minimum duties that needs to be done in every state. So I think this bankruptcy side of this is quite established, and then restructuring proceedings, the fees are maybe coming more of the nature of the cases and what needs to be done, and also debtor is the one who pays the fees, so it's kind of more like freely formed a level at that point.
Yeah, so based on your questions and the panelists' answers, excuse me, I think that it's fair to conclude that we are probably not expecting too many changes, because this matter has been dealt with quite well in Finland. So that would be my conclusion about that issue. And then as a last issue and last question, I would ask about the liability insurance that would be taken by the insolvency practitioner. There is certain stipulation regarding that also in the directive. Pekka, what is your experience and understanding about the liability matters and insurances connected to those? Has this developed during during your career?
Yeah, thank you. This is an interesting and a very good question. First of all attorneys who are members of the Finnish bar, they must have a compulsory insurance, and that insurance coverage will cover them once they are acting as an administrator or a trustee in various proceedings. Or even sometimes if they are acting as a board member, the company insurance will give a coverage. Of course, we do have also non-attorneys or even non-lawyers who are acting as a trustee or administrator, and then of course this might be a different issue. But as far as attorneys are concerned, this is not an issue. If we go back to the 90s or 80s or even 70s, that I do remember that it was very typical at that time that the estate itself or the trustee took on behalf of the assets in the estate a separate insurance, which was then paid by the estate. Even today, perhaps in case by cases, the business of the debtor might be something that you need a special or extra coverage, and then of course it's good to discuss with the creditors and the debtor if that is the case. But the main answer is that the attorney's insurance policy do cover acting as a trustee.
Maybe I ask Helena about this alternative, that there would be some kind of a extra insurance. Helena, how does that sound in your ears, so to say? Would it be possible for the creditors to decide upon that extra coverage in special cases?
Yeah, why not? If the decision is made in the creditors meeting and it is like properly done, so that the majority is on behalf of extra insurance coverage, is of course possible, but I think only in special cases, and there should be some kind of special reason for that, so that usually it is taken care of, so that the IPs take care of this their own insurances.
Tuomas, any thoughts on this particular matter?
No more than what has been said already by Pekka and Helena. Perhaps when I say I have a full confidence in you, yeah, you will take the all the insurances that are needed. I trust you.
Okay, I think we have been reserved with 20 minutes of time, and this was our last topic. I mean, the conclusion would be that IPs usually, I would say as a main rule, have an insurance, and there may be some limited cases or situations where extra coverage could be, so to say, an alternative. I would like to thank you, all the panelists, for these very interesting discussions. I thank all the listeners of this video for your attention, and I hope and wish you all a safe and healthy winter. I hope that we will be able to meet in person in seminars and congresses as soon as possible, both at INSOL Europe and at the Finnish Insolvency Law Association. Thank you very much and have a good day. Bye-bye.
Thank you.
Bye.
Bye-bye.